Hi, I'm Stephen Wood, your trusted estate planning attorney here at Wood Law Wills and Trusts. And today I want to talk about a common mistake parents make when naming beneficiaries on life insurance policies and retirement accounts. Many parents assume that if something happens to them, they should simply name their children as the beneficiaries. While that sounds logical, it's usually not the best option when your children are minors. Here's why. A minor cannot legally receive and manage an inheritance directly. If a life insurance policy or retirement account pays out to a child under 18, a court will likely need to appoint someone to manage those funds until the child becomes an adult. That means additional time, expense, court involvement, exactly the kind of hassle most parents are trying to avoid. Even more concerning, once the child reaches the age of majority, 18 in California, the entire inheritance is distributed outright to them. Most parents don't want an 18-year-old receiving a large sum of money with no restrictions or guidance. Some parents realize this problem I just described and make another mistake though. They name a trusted relative, such as an aunt, uncle, or grandparent, as the beneficiary, thinking that person will manage the money for the children. The problem is that the money will legally belong to the named beneficiary. Even if the beneficiary has the best intentions, circumstances change. They could get divorced, have creditor problems, become disabled, pass away unexpectedly, or simply decide not to use the money the way you intended. The children may have little or no legal right to those funds. In case of a retirement account, this can create additional tax as well. A much better solution is to name a properly drafted trust as the beneficiary. When you name your trust, the money goes directly into the trust and is managed by a trustee you selected. The trustee follows instructions that you created in advance. You can specify how the funds are used for education, healthcare, housing, other needs. You can also determine when your children receive their inheritance. Instead of getting everything at age 18, you might choose ages 25, 30, or even later. You can provide protection and guidance during the years when they need it most. A trust also helps avoid unnecessary court involvement and gives you much more control over how your assets are managed and distributed. The bottom line is this: if you have minor children, don't assume that naming them or another family member as a beneficiary is the right answer. Beneficiary designations should be coordinated with your overall estate plan, and a trust gives you the most control. If you'd like help reviewing your beneficiary designations and making sure they're aligned with your trust, contact Wood Law Wills and Trusts. We'd be happy to help. Thanks for watching.